Hey, I'm Alexei from Lexawise, and welcome to our crash course on real estate contracts. Today, we'll break down the key elements, types, and important clauses of real estate contracts. Everything you need to know to ace your licensing exam. Before we dive in, remember you can find all this info and more on the Lexawise blog and in our exam prep resources. Let's jump right in.
Lexawise, Real Estate Exam Prep.
First off, what's a real estate contract? A real estate contract is a legally binding agreement between parties for things like buying, selling, or leasing property. Think of it as the blueprint for the deal. It lays out all the terms and conditions so everyone knows exactly what to expect. For example, if you're buying a house, the contract will include details like the purchase price, closing date, and any contingencies, like the results of a home inspection. It ensures that both the buyer and seller are on the same page and protects everyone involved in the transaction. For a contract to be valid, it must comply with these elements: offer and acceptance. It all starts with one party making an offer and the other accepting it. This shows that both sides are on the same page, which is the foundation of any contract. If the offer is accepted, the contract can become a valid and legally binding agreement. Consideration. In every contract, something of value called consideration is exchanged. In real estate, this usually means the buyer offers money and the seller provides the property in return. Legal capacity. Parties must have the legal ability to enter into a contract, meaning they are of sound mind and legal age. Lawful purpose. The contract's purpose has to be legal. It can't involve anything illegal or go against public policy. For example, you can't enforce a contract for something like selling property you don't legally own. Now, a quick test. Let's practice these concepts with exam-like questions from Lexawise Exam Prep. First question. When does Martin's offer to purchase a home, which she made to her agent Patrick and accompanied by a check, become a legally binding and enforceable contract? A. When Martin is notified, the seller accepts the offer. B. When Patrick receives her offer and her check. C. When the deposit check clears. D. When the offer and the check are received by the seller. Think about it for a bit. Do you know the answer? The correct answer is A. When Martin is notified, the seller accepts the offer. Why? Because if the offer is accepted by the seller, it becomes a legally binding agreement that cannot be withdrawn without consequences, such as the loss of the earnest money deposit. Second question. Which of the following may be categorized as consideration? A. Labor. B. All of the other options may be considered consideration. C. Money. D. A commitment. Take your time. Got it? B is the correct answer. Consideration is anything of legal value that motivates someone to enter a contract. So all of the options can be categorized as consideration. And here's the third question of our quick test. How would the incompetence of one party affect a contract? A. It would make the contract enforceable. B. It would make the contract valid. C. It would make the contract voidable. D. It would make the contract void. Think about it. Got it? The answer is D. It would make the contract void. If one of the essential elements is not present in a contract, that contract was never valid, so it is void. As I said before, these essential elements are competent parties, lawful object, offer and acceptance, and consideration. If one party is not legally competent, then the contract is void. Now that we've got this covered, let's move on to the types of real estate contracts. When it comes to real estate, there's no one-size-fits-all contract. Different situations call for different agreements, whether you're buying, renting, or working on something more specialized. Let's dive into the most common real estate contracts and what they're all about. Sales and purchase agreement. These are the most common contracts, detailing the sale of property from seller to buyer. They include terms like purchase price, closing date, and contingencies. Lease agreement. Contract between a landlord and tenant outlining the terms of property rental, including duration, rent amount, and maintenance responsibilities. Let's explore the main different types of leasehold estates. Estate for years. An estate for years is a leasehold that lasts for a fixed period. such as 6 months or a year. This type of lease has a definite beginning and end date. Once the lease term ends, the tenant must vacate the property unless a new lease is negotiated. Estate from period to period, periodic tenancy. This type of lease automatically renews for successive periods, such as month to month or year to year, until the landlord or tenant terminates it. Notice is required to terminate this type of tenancy, and the notice period typically matches the rental period. Estate at will. An estate at will is a leasehold interest that lasts as long as both the landlord and tenant desire. With proper notice, either party can terminate it at any time. Because of that, an estate at will offers flexibility and uncertainty for both parties. Estate at sufferance. An estate at sufferance happens when a tenant retains possession of the property without the landlord's consent. An example can be when the tenant is notified that the lease is terminated and they don't go, or when a tenant doesn't pay the rent. In that case, the landlord can evict the tenant at any time, and the tenant may be liable for damages. Let's continue with the other contract types. Assignment contract. Used primarily by wholesalers, these contracts allow the original buyer to transfer their purchase rights to a new buyer before closing. Land contract. A land contract, also known as a contract for deed, is a seller-financed option for buyers who can't secure a traditional mortgage. Instead of borrowing from a bank, the buyer makes loan payments directly to the seller until the property is fully paid off. Depending on where you are, this type of agreement might also be called an installment land contract or a bond for title. In a land contract, the seller is also known as the vendor, and the buyer is also known as the vendee. And the last one of this list, listing agreements. These types of contracts are between a property owner and a real estate broker. In them, the property owner authorizes the broker to find a buyer for their property. In exchange, there can be commission for the broker, depending on the agreement they both sign. These are just a few of the common real estate contracts, but there are plenty more, each designed for specific situations. All right, now let's talk about the different types of listings. This part is super important for your exam. Open listing. The seller can hire multiple brokers, and only the broker who finds a buyer gets paid. The seller can even sell the home themselves and pay no commission. This is rare in standard home sales. Exclusive agency listing. Only one broker is hired, but if the seller finds the buyer, they don't owe the broker a commission. The broker must prove they were the reason for the sale to get paid. Exclusive right to sell listing, the most common type. The broker gets paid no matter who finds the buyer, even if the seller brings one in. This is the preferred agreement for brokers. Net listing, illegal in most states. The seller sets a minimum price, and the agent keeps anything above that as commission. This creates a conflict of interest, which is why most states ban it. Quick test of this part. First question: when a purchase contract is signed and the buyer wants to give it to another party, this is called A. Conversion, B. Commingling, C. Subordination, D. Assignment. Can you guess the answer? Think. D is the correct option. When a buyer signs a purchase contract with a seller, they usually have to complete the purchase. But sometimes the buyer may want to transfer their part of the contract to someone else. This is called an assignment. Second question: what are the terms to describe the seller and the buyer in a land contract? A. Vendee and vendor. B. Vendor and vendee. C. Grantee and grantor. D. Grantor and grantee. Think about the answer. Got it. The correct option is B. As I said before, a land contract is an agreement between a seller, also known as the vendor, and a buyer, also known as the vendee. Third question: a lease of real property that has a specified duration is regarded as A. an estate at sufferance, B. an estate for years, C. periodic tenancy, D. a life estate. Think about it. B is the correct option. An estate for years is a lease for a set period of time, which can be any length, even though the name might suggest otherwise. The end date of the lease is decided when the lease is signed. It doesn't automatically renew. And an extra one: which type of listing agreement does not require a broker to demonstrate they were the procuring cause of the sale to be eligible for a commission? A. Net listing. B. Exclusive authorization and right to sell. C. Open listing. D. Non-exclusive listing. All right, think about it. B is the correct choice here. In an exclusive authorization and right to sell listing agreement, the seller agrees to work exclusively with the listing broker to sell the property. Unlike other agreements, the broker doesn't need to prove they were the cause of the sale or the procuring cause to earn a commission. Let's move on to the final part of this crash course. Another thing you can't overlook in a real estate contract is the clauses. They're the backbone of the agreement. The details they outline can make or break a deal, so understanding them is a must. Each clause is there to protect both the buyer and seller, making sure everything is crystal clear and agreed upon. Here are some of the most essential ones. Financing terms specifies how the purchase will be financed, including loan type and terms. Inspection contingency allows the buyer to have the property inspected and negotiate repairs or cancel the contract based on findings. Appraisal clause ensures the property appraises at or above the purchase price, protecting the buyer's investment. Safety clause. A safety clause in a listing agreement guarantees the broker gets a commission if the property sells after the agreement ends, protecting their efforts in finding the buyer. It stops the seller from cutting out the broker if the sale happens right after the listing expires. Title contingency requires a clear title, free of liens or disputes, before completing the transaction. Closing date sets the date when the property ownership will be transferred. Earnest money deposit, a deposit made by the buyer to demonstrate serious intent, which may be forfeited if the buyer breaches the contract. Fixtures and appliances specifies which items are included in the sale, such as lighting fixtures or kitchen appliances. And here's the last quick test of this video. First question, what is a closing date? A. The date on which the buyer takes possession of the property. B. The date on which the seller receives payment for the property. C. The date on which the real estate contract becomes binding. D. The date on which the closing of the real estate transaction takes place. Think about it. Got it? The answer is D colon. The closing date is when the real estate transaction is completed and ownership is transferred from the seller to the buyer. It's usually set in the purchase agreement and is negotiated between the buyer and the seller. The closing typically happens at the closing agent's office, the title company, or the lender's office. Second question. Where can a safety clause be found? A. In a listing agreement. B. In a deposit receipt. C. In a lease. D. In a loan broker's statement. Can you guess the answer? A is the correct one. A safety clause in a listing agreement ensures the broker gets a commission if the property sells after the agreement ends, protecting their role in bringing the buyer to the property. Third and last question, what is the appropriate action for a broker? If a purchase contract specifies that the earnest money is to be released to the buyer after a home inspection is complete, but the buyer requests that the earnest money be released prior to the inspection. A. Notify the seller of the buyer's request, and if all parties to the contract agree, it can be released. B. Release the money to the buyer. C. Refuse to release money to the buyer. D. Release the money to the buyer obtaining only the seller's verbal agreement. So, try to answer this one. Got it? A is the correct option. Notify the seller of the buyer's request, and if all parties to the contract agree, it can be released. If the seller and other relevant parties agree to the buyer's request to release the earnest money before the inspection, the contract terms can be changed. If any party does not agree, the original terms stand and the earnest money won't be released until after the inspection. And that's a wrap for today. Thanks for watching. For more exam prep resources, be sure to visit our website. There's a link in the description below. If you have questions or need anything clarified, drop a comment. We're always here to help. Don't forget to like, subscribe, and share this video with your fellow future agents. See you in the next video.